Judgment in the matter of Takhar versus Gracefield Developments Limited and others.
Mrs. Balba Takhar and Mrs. Tarkash Krishan are cousins. They had not seen each other for several years before 2004. In that year, they met again, and their former friendship resumed. Now, in 2004, Mrs. Takhar owned a number of properties in Coventry. She was experiencing difficulty in managing some of these, and her cousin, Mrs. Krishan, and her husband, Dr. Krishan, agreed to help. In order to set affairs between them on a proper footing, it was agreed that a new company, Gracefield Developments Limited, be set up. Mrs. Takhar and the Krishans were to be the shareholders and directors, and Mrs. Takhar's properties were to be handled through this company. This much is agreed between the parties. Mrs. Takhar claims, however, that although legal ownership would pass to Gracefield, she would remain the beneficial owner of the properties. According to her, they would be renovated and then let. The rent would be used to meet the costs of renovating the properties. But before they could be let, however, in the short term, the cost of renovation was to be met by the Krishans. Now, the Krishans present a very different account from that given by Mrs. Takhar. They claim that Gracefield was set up as a joint venture company, and according to them, the properties were to be sold after they had been renovated. They were to be given an agreed value, which would be paid to Mrs. Takhar after they had been sold. And any profit over, they said, it was agreed would be divided equally between them and Mrs. Takhar. These differing accounts led to a dispute between the parties and to the issue of legal proceedings by Mrs. Takhar against the Krishans. She claimed that the properties had been transferred to Gracefield as a result of undue influence and other unconscionable conduct on the part of Dr. and Mrs. Krishan. And in a judgment delivered on the 28th of July 2010, His Honour Judge Purle QC rejected that claim. Now, a significant item of evidence in the hearing before Judge Purle was a written profit share agreement dated the 1st of April 2006. It provided for an initial purchase price for the properties. This was to be placed on a loan account with Gracefield, and further sums were also provided for. The total of these sums was to be paid to Mrs. Takhar on completion of the sale of the properties. She was also to receive 50% of the profits on the sale of each property. This was powerful evidence in support of the Krishan's case, and the judge, unsurprisingly, relied heavily on it in finding in their favour. But in advance of the hearing before Judge Purle, Mrs. Takhar had applied for permission to have the only copy of the written agreement that was available examined by a handwriting expert. That application was refused because it was considered that it had been made too late. In the course of the trial, Mrs. Takhar said that she could not say that the signature on the profit share agreement was not hers, but she was quite unable to explain how it had got there. After the trial, Mrs. Takhar instructed new solicitors, and she asked them to obtain a report from a handwriting expert. An expert was duly engaged, and in his report he stated that the signature on the profit share agreement, which purported to be that of Mrs. Takhar, had been transposed from a letter which she had sent to the Krishan solicitors. After receiving this report, Mrs. Takhar issued proceedings in which she sought to have Judge Purle's judgment and order set aside. She claimed that she was entitled to this relief on the ground that they had been obtained by fraud. The Krishans defended the proceedings, saying that Mrs. Takhar's claim was an abuse of process, inter alia because the documents on which the expert's report was based were available to Mrs. Takhar and her legal team since at least the 12th of July 2009, approximately 12 months earlier than the trial before Judge Purle. The question whether Mrs. Takhar's claim was an abuse of process was tried as a preliminary issue by Mr. Justice Newey. He held that it was not, and that Mrs. Takhar's claim should be allowed to proceed to trial. It had been argued before him that a party who seeks to set aside a judgment on the basis that it was obtained by fraud had to demonstrate that he could not have discovered the fraud by the exercise of reasonable diligence. And Mr. Justice Newey rejected that argument. The Krishans appealed. The Court of Appeal decided that there was a requirement of reasonable, or as it is sometimes called, due diligence, before a party can proceed with a claim that a judgment should be set aside on account of its having been obtained by fraud. Mrs. Takhar appealed the Court of Appeal's decision to this court. This court unanimously allows Mrs. Takhar's appeal. We have decided that reasonable diligence is not an invariable requirement in a case where a claim is made that a judgment obtained by fraud should be set aside. 4 judgments have been prepared, and a difference in approach, or perhaps a difference in emphasis, appears between them. In my judgment, I say that it ought now to be recognized that where it can be shown that a judgment has been obtained by fraud, and where no allegation of fraud had been raised at the trial which led to that judgment, a requirement of reasonable diligence should not be imposed on the party seeking to set aside the judgment. I allude to 2 possible qualifications to that statement. Where fraud has been raised at the original trial, and new evidence as to the existence of the fraud is prayed in aid to advance a case for setting aside the judgment, it seems to me that it can at least be argued that the court, having to deal with that application, should have a discretion as to whether to entertain it. The second qualification relates to the possibility that in some circumstances, a deliberate decision may have been taken not to investigate the possibility of fraud in advance of the first trial, even if that had been suspected. If that could be established, again, I believe that a discretion whether to allow an application to set aside the judgment would be appropriate. But since neither situation arose here, I have not expressed any final view on those matters. I consider that Mrs. Takhar should be allowed to proceed with her claim to have the judgment set aside, and 3 other members of the court expressly agree with that conclusion. Lord Sumption expressed the provisional view that even where fraud had been raised in the original proceedings, the position should be the same as that where it had not been. Lord Briggs considers that it would be wrong in principle to say that the generality of applications to set aside judgments for fraud are entirely unaffected by questions about lack of reasonable diligence. He commends a more open-ended approach to the question whether reasonable diligence should be regarded as a requirement in individual cases. But he concludes that this case, the case of Mrs. Takhar, falls clearly on what he described as the non-abusive side of the line. Lady Arden examines a number of possible exceptions to the general rule that fraud unravels all, where, for instance, both parties have colluded to deceive the court, or where fraud is not material to the outcome. Among the members of the panel, Lady Arden suggests that it's for the respondents to decide whether to renew their application for an order barring the claim as an abusive process. It's clear from the other judgments that that is not deemed to be an option that remains available to the respondents.